Welcome in. It is really fantastic to have you joining us today for this deep dive. We spend a lot of time thinking of the law in black and white terms.
Right, like stealing a candy bar from a corner store, obviously theft.
Exactly. Or swiping a car from a parking lot. Definitely theft. But today, we are tackling a legal problem that gets surprisingly gray, surprisingly fast. We're looking at a fundamental question. How exactly does the law define theft when the nature of the property itself changes? Or when the way that property was acquired isn't your standard smash and grab?
It's a question that completely reshapes how we understand criminality. Because the moment you move away from that classic image of, a masked burglar slipping a diamond into a velvet bag,
Yeah,
the legal mechanics have to completely adapt.
exactly. So, our mission today is to rigorously dissect the Model Penal Code, often referred to as the MPC, specifically focusing on its rules regarding theft. We are going to tear down sections 223.2 and 223.5, breaking down the exact testable elements that prosecutors absolutely must prove to establish that a crime has occurred. But we aren't just going to read you a textbook. We want to figure out why the law draws these incredibly specific lines.
And to do that, we have a clear analytical roadmap for you. Over the course of this deep dive, we are going to examine the distinct legal doctrines required for taking what the code calls movable property versus immovable property under Section 223.2. We will explore the crucial policy reasons behind why the drafters felt the need to split these two apart.
Right.
After that, we'll tackle the rather unique rule for property that is lost, mislaid, or mistakenly delivered to you under Section 223.5. We will lay out the black-letter law, but more importantly, we'll give you the elemental breakdowns you need to truly grasp these concepts in the real world.
Okay, let's unpack this. We will start with Section 223.2 on theft by unlawful taking or disposition. How exactly does the MPC handle the classic, traditional idea of stealing a physical object?
The MPC addresses this in Section 223.2, subsection 1, which governs movable property. The explanatory notes point out that this section deals with conduct traditionally known as the larceny embezzlement type.
Okay, so to make sure we're looking at this methodically, let's set up a scenario. Since we're looking purely at the statute today, let's use a highly visceral hypothetical to stand in for our case law. We will call this the case of the rival's gallstones.
Oh, wow.
Yeah, bear with me. Imagine someone holds a serious, deep-seated grudge at work. They sneak into their workplace rival's office after hours. On the desk sits a bizarre trophy, a jar containing the rival's surgically removed, highly prized gallstones. The person secretly takes the jar, sneaks it out of the room, and takes it home, hiding it permanently in their own basement. Let's analyze the case of the rival's gallstones. First, what are the legally dispositive facts?
I mean, that is incredibly gross. But legally speaking, a concise summary of the essential facts would be an unauthorized entry. The physical removal of a jar containing biological anomalies belonging to a rival, transporting that jar out of the building, and permanently concealing it in a residential basement.
Right, and what was the core legal issue?
The precise legal question here is whether this bizarre act of secretly removing and hiding the jar of gallstones constitutes theft of movable property under MPC Section 223.2, subsection 1.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The black-letter law states that a person is guilty of theft if they unlawfully take or exercise unlawful control over movable property of another with purpose to deprive him thereof. The rule has three elements. First, unlawfully takes or exercises unlawful control over. Second, movable property of another. And third, with purpose to deprive him thereof.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, unlawfully takes or exercises unlawful control?
To analyze this element, the real sub-issue is whether the physical act of removing the jar constitutes an assertion of dominion. The legal standard requires an assertion of control over the item in a way that infringes on the rightful possessor's rights. By physically grasping that jar, removing it from the rival's desk, and sneaking it out of the room, the actor has severed the rival's control and substituted their own without permission.
Yeah, they just took it.
Exactly. So applying those facts, a court would unequivocally conclude that this specific physical movement satisfies the first element of unlawful taking or control.
Understood. Now, what about the second element, movable property of another? I mean, we are talking about bodily waste here. Does that legally qualify as property?
It absolutely does. The sub-issue is defining what constitutes movable property. The sub-rule is that the property must be capable of being physically moved and must have an owner other than the actor. The facts show the jar was physically carried out of the office, which easily proves it is movable. Furthermore, even though they were once part of someone's body, the gallstones were surgically removed, preserved, and kept by the rival as a personal item, establishing clear ownership rights.
Right.
Applying those facts, a court would find that the jar of gallstones is indeed the movable property of another, satisfying the second element.
Understood. Now, what about the third element, with purpose to deprive him thereof? What if they were just playing a terrible prank?
That is where the actor's mental state becomes the crucial sub-issue. The law requires the actor to have a conscious objective to withhold the property permanently. Looking at our facts, the actor didn't just hide it in the office fridge, they took the jar home and hid it permanently in their basement. That deliberate concealment demonstrates a conscious objective to ensure the rival never sees their prized property again. Thus, the court would conclude the third element is fully met.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing the elemental analysis, because the actor unlawfully took control, the property was movable and belonged to the rival, and the actor had the purpose to permanently deprive the rival of it, all elements are satisfied. The ultimate holding is that stealing the gallstones results in full liability for theft of movable property.
That makes perfect sense for things you can physically carry away. But you can't exactly stuff a commercial building into your backpack. How does the law treat real estate?
That brings us to Section 223.2, subsection 2, regarding immovable property. The drafters of the MPC had to create a distinct framework for this.
If we connect this to the bigger picture, I noticed a major shift in the language. We went from unlawfully takes to unlawfully transfers. Why that specific distinction?
It's a critical policy distinction. Immovable property is principally real estate. The major policy purpose behind requiring an unlawful transfer rather than an unlawful taking is to strictly avoid assigning severe theft liability for conduct that is merely a trespass. The drafters didn't want someone who simply occupies real property beyond the terms of their lease to be thrown in prison as a thief.
So it keeps civil matters in civil court. Let's test this policy constraint. We will call this the case of the gruesome slaughterhouse. Imagine two different individuals interacting with a decaying, rat-infested commercial slaughterhouse. Person A is a squatter. They rented the slaughterhouse for a month but maliciously overstayed their lease, refusing to leave and locking the owner out. Person B is a fraudster. They completely forged the legal deed to that same slaughterhouse in order to permanently transfer legal ownership to their cousin. Let's analyze the case of the gruesome slaughterhouse. First, what are the legally dispositive facts?
For person A, the squatter, we have a lawful initial rental, followed by an intentional refusal to vacate. For person B, the fraudster, we have the fabrication of a legal property deed to a slaughterhouse they do not own, executing that forged document, and officially assigning ownership rights to a relative.
And what was the core legal issue?
Between the squatter and the deed forger, who is actually guilty of theft of immovable property under MPC Section 223.2, subsection 2.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
A person is guilty of theft if he unlawfully transfers immovable property of another or any interest therein with purpose to benefit himself or another not entitled thereto. The rule has three elements. First, unlawfully transfers. Second, immovable property of another or any interest therein. And third, with purpose to benefit himself or another not entitled thereto.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. First, looking at the squatter. How did the court apply the first element, unlawfully transfers?
For person A, the sub-issue is whether overstaying a lease constitutes a transfer. The legal standard requires conveying a legal interest or title, not merely occupying physical space. Applying the facts, person A only physically occupies the slaughterhouse. They haven't executed any document or used any legal mechanism to convey title.
So they fail the element.
Exactly. The court would conclude person A completely fails to meet the first element. Because of that failure, the analysis for the squatter ends right there. No theft.
Understood. Now what about applying that same first element, unlawfully transfers, to person B, the deed forger?
For person B, the sub-issue is whether forging a deed constitutes an unlawful transfer. Applying the standard regarding the conveyance of a legal interest, person B's act of fabricating a deed is the exact mechanism used to legally convey title without permission. The court would conclude that forging the deed satisfies the first element.
Understood. Now what about the second element, immovable property of another?
The sub-rule defines immovable property principally as real estate or land. The facts establish the slaughterhouse is a commercial building permanently affixed to land owned by a third party. The court would easily conclude the second element is satisfied.
Understood. Now, what about the third element, with purpose to benefit himself or another not entitled thereto?
This brings up the actor's mental state. The standard requires a conscious objective to bestow a legal advantage upon someone lacking a rightful claim. The facts state person B forged the deeds specifically to give ownership to their cousin, who had no prior legal right. The court would conclude this perfectly demonstrates the purpose to benefit another not entitled thereto.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing the analysis, person A only committed a trespass, failing the core element. Person B unlawfully transferred immovable property belonging to another with the purpose of benefiting their cousin. The ultimate holding is that only person B committed theft of immovable property.
I love how perfectly this illustrates the statute's intent. Here's where it gets really interesting, though. We've talked about actively taking movable things and actively transferring immovable things. But what happens if you don't actually take anything at all? What if property simply falls right into your lap by pure chance?
That shifts our focus to Section 223.5, which covers theft of property lost, mislaid, or delivered by mistake. This section fundamentally departs from most prior common law.
Really? How so?
Historically, courts used to get hopelessly bogged down trying to determine the original owner's intent. Was the item lost, meaning it slipped out accidentally, or was it mislaid, meaning they intentionally set it down and forgot it?
Ah, I see.
The MPC creates a general offense that explicitly abandons those traditional distinctions. It focuses entirely on the actions and knowledge of the person who finds the property.
Let's put this modern rule to the test. We'll call this the case of the giant squid. Imagine a courier mistakenly delivers a massive heavy cooler to your doorstep. You bring it inside, open it, and find a remarkably expensive, legally sourced, preserved giant squid. It was clearly meant for a wealthy, eccentric billionaire's private aquarium. You look at the shipping label, you clearly see the billionaire's name, but you decide you want it for yourself. You throw the shipping label in the trash, seal the cooler, and hide it in your basement permanently. Let's analyze the case of the giant squid. First, what are the legally dispositive facts?
A cooler containing a highly valuable preserved squid was delivered to the actor's home. The actor opened it, read a shipping label indicating it was intended for someone else entirely, threw that identifying label in the trash, and permanently concealed the cooler.
Right, and what was the core legal issue?
Does keeping this mistakenly delivered giant squid constitute theft under MPC Section 223.5?
Exactly. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
A person who comes into control of property of another that he knows to have been lost, mislaid, or delivered under mistake as to the nature or amount of the property or the identity of the recipient is guilty of theft if, with purpose to deprive the owner thereof, he fails to take reasonable measures to restore the property to a person entitled to have it. This rule has 4 elements. First, comes into control of property of another. Second, knows it to have been lost, mislaid, or delivered under a mistake. Third, fails to take reasonable measures to restore the property. And fourth, with purpose to deprive the owner thereof.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step.
Yeah.
How did the court apply the first element, comes into control of property of another?
The sub-issue is whether receiving a package at one's home equates to coming into control. The standard is that physical possession and the ability to dictate what happens to the item constitutes control. By physically bringing the cooler inside and opening it, a court would easily conclude you've satisfied the first element.
Understood. Now what about the second element, knows it to have been delivered under a mistake?
The legal standard requires subjective awareness of the error, meaning you actually knew in your own mind that a mistake regarding the identity of the recipient had occurred. Because the facts state you looked at the shipping label and saw the billionaire's name and address, a court would determine you had undeniable explicit knowledge of the mistaken identity. That squarely satisfies the second element.
Understood. Now what about the third element, fails to take reasonable measures to restore the property?
The sub-issue here is evaluating your subsequent conduct. The law doesn't demand you hire a private detective, but it requires evaluating whether you made a baseline logical effort to contact the owner. In our hypothetical, you immediately tossed the identifying shipping label into the trash and hid the cooler. You took active, destructive measures to prevent restoration. A court would conclude this total failure to act responsibly satisfies the third element.
Understood. Now what about the fourth element, with purpose to deprive the owner thereof?
The mental state required is a conscious objective to permanently withhold the property. Deliberately choosing to keep the squid for yourself and hiding it permanently in your basement perfectly fulfills the purpose to deprive requirement of the fourth element.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing that analysis, because the actor controlled the property, had explicit knowledge of the mistake, took zero measures to return it, and fully intended to keep it forever, all four elements are completely satisfied. The ultimate conclusion is that keeping the mistakenly delivered giant squid is theft under Section 223.5.
That is wild, but it makes complete sense when you break it down element by element.
Exactly. And as we wrap up our doctrinal analysis today, I want to synthesize this into a final actionable diagnostic checklist for you. You can use this mental framework for issue spotting theft under the MPC. Think of it in 5 steps. Step 1, identify the nature of the property acquisition. Was it actively taken or passively received, like being lost or delivered by mistake? Step 2, if it was actively taken, classify the property as either movable or immovable. Step 3, if it's movable property, check for the elements under 223.2 subsection 1. Unlawful taking or control paired strictly with the purpose to deprive. Step 4. If it's immovable property, evaluate under 223.2 subsection 2. Strictly look for an unlawful transfer of a legal interest paired with a purpose to benefit. Remember the policy carve-outs. Do not apply the statute to simple lease, overstays, or trespasses. There must be a transfer of interest. Step 5. If the property was passively received, like our mistaken squid delivery, analyze under 223.5. Check for actual knowledge of the mistake, the failure to take reasonable restoration measures, and the underlying purpose to deprive.
So what does this all mean for you in your daily life? We've broken down the strict legal elements using some wild hypotheticals today, but the real world is messy and happens every day. Think about the era we live in right now. We are constantly receiving misdelivered Amazon packages on our porches or finding stray items left behind in the backseat of Ubers. Under Section 223.5, what exactly constitutes reasonable measures to restore property today? Does the purpose to deprive element mean you are legally safe if you are simply too busy or too lazy to mail back a mistaken package for a few weeks? Or does your passive inaction, letting that box sit unopened in your hallway month after month, eventually morph into a criminal purpose to deprive? It is an incredibly fine line between modern laziness and statutory theft. I encourage you to mull over that thought the next time a package with the wrong name shows up on your doorstep. Thank you for joining us for this deep dive into the Model Penal Code.